Good morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is January 29th, 2020. It's Wednesday, 9:30 in the morning. With us today are Commissioners Emily Lindley and Bobby Janeka and our General Counsel Mary Smith. I'm John Neerman, and Ms. Smith, I'll ask you to please begin the proceedings.
Old business, item 1 is an agreed petroleum storage tank enforcement order, and the Office of General Counsel would recommend that the Commission take this item up with the remainder of the enforcement docket later in the meeting.
Good.
New business, item 1, is the application by Collier Materials Incorporated for new air quality permit number 152092L001. The parties have been notified that the commissioners will not hear oral argument but may ask questions. We have several people signed in on this, and those people's presence will be noted for the record.
So again, good morning. For the benefit of those who are not familiar with our process, we have a two-part analysis for considering requests for contested cases. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And assuming we have at least one requester that's done that, we consider which issues are appropriate to refer to a hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit, both in timely comments and also in a hearing request, are entitled to a hearing. For governmental entities to be affected persons, they also have to have authority under state law over issues raised by the application. And colleagues, I'm going to recommend that we do grant some of these requests, and I'll begin with the local governments. Llano County filed several hearing requests, and in my view, it does meet the requirements for party status. The city of Sunrise Beach, however, is not an affected person because the proposed facility is outside the city's ETJ, and the city didn't demonstrate the authority to regulate outside those boundaries or that its citizens would be affected in a manner different from the general public. Let me pause there and see if you all have any different or additional thoughts, and then I can turn to the individuals.
I'm in agreement.
Likewise.
Okay, so well, let me just tell you which I would suggest that we grant. I would grant the following hearing requests. I would grant the hearing requests of Catherine and Randy Binder, Tracy Black, Erwin Johnson, Luann Ray, Richard and Mary Miller, Winnie Tate Morgan, David Oswald, Kathy Stockton, Carla and Max Ramsey, Miriam Redwine, Jesus Vasquez, and Patsy and John Wiley. And I would deny the remaining hearing requests. Most of the requesters that I would propose that we deny live too far from the proposed facility to be affected in a manner different than the general public. Mm-hmm. Some of the others failed to submit timely comments, and some failed to articulate a personal concern about the permit. So, for example, I agree with Public Interest Counsel and the Executive Director that Cindy and Rick Angley and also John Gibbons failed to state a personal justiciable issue. Let me check in, see how we're doing.
I'm in agreement.
That's how I came down as well.
Okay. So that was part 1 about who gets a hearing. Let me turn to the issues. And again, for the folks who, benefit of the folks who aren't familiar with the process, we refer issues that have been timely raised by an affected person and that are relevant and material to the application. Stated a different way, the issues have to be within our jurisdiction on this type of application. So, for example, we can't consider economic impacts, such as impacts to property values. We generally can't consider increased traffic or noise. We generally can't consider air quality concerns in connection with a water quality permit or water quality concerns in connection with an air quality permit, just to provide a few examples. So there were dozens of issues raised in this matter, many of them overlapping, and I would sort them out and into 10 issues that I would refer. as follows. The first few relate to the sufficiency of the permit. So the first is whether the permit will protect the health and safety of the requesters and their families, will negatively affect air quality, will be protective against dust, including nuisance dust emissions. The fourth is whether the proposed facility will adversely affect the use and enjoyment of the requester's properties. The fifth is whether the proposed facility will adversely affect animals and vegetation. Next is whether the emissions from on-site diesel engines will negatively impact the health and welfare of the requesters and their families. Whether the application includes adequate information to develop the permit. Whether the application and the air modeling properly evaluated all applicable emissions. Whether a site inspection was performed. And finally, whether the applicant complied with sign posting requirements. So how'd we come out?
I'm in agreement, and you might be about to say this, but I would also recommend that we deny all the requests for reconsideration.
I agree.
Agreed on both counts.
I think
I think that covers.
disposes of all the issues, and so I'm ready to entertain a motion.
And length of hearing, customarily, the 180 days would be appropriate?
Yeah.
I agree.
Good.
I move that we grant the hearing request of Llano County, Catherine and Randy Binder, Tracy Black, Erwin Johnson and Luann Ray, Richard and Mary Miller, Winnie Tate Morgan, David Oswald, and Kathy Stockton, Carla and Max Ramsey, Miriam Redwine, Jesus Vasquez, and Patsy and John Wiley. That we deny the remaining hearing requests and all requests for reconsideration. That we refer the matter to SOA for a contested case hearing on the following issues. A, whether the permit will be protective of the health and safety of the requesters and their families, including sensitive groups. B, whether the permit will negatively affect air quality. C, whether the proposed facility will adversely affect the use and enjoyment of the requester's properties. D, whether the proposed facility will adversely affect animals and vegetation. E, whether the permit will be protective against dust emissions generated from the proposed plant, including nuisance dust emissions. F, whether the application contains sufficient and accurate information for TCEQ to develop a draft permit. G, whether emissions from on-site diesel engines will negatively impact the health and welfare of the requesters and their families, including sensitive subgroups. H, whether a site inspection was performed. I, whether the permit application and associated air dispersion modeling included and properly evaluated all applicable emissions. And J, whether the applicant substantially complied with TCEQ's public notice requirements related to sign posting. And that we specify the maximum duration of the hearing is 180 days from the preliminary hearing to issuance of the proposal for decision.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries.
Thank you, thank you. Thank you, Mr. Jones.
Yeah.
Quite a turnout.
Item number 2 is the application by DR Horton, Texas Limited for new TPDES permit number WQ 0015686001. The parties have been notified that the commissioners will not hear oral argument but may ask questions. Those that have signed in will be noted for the record.
So colleagues, we have numerous requests on this matter as well. Let me begin again with the local governments. The City of Dallas and the City of Garland both raised issues that are within their authority, so I would grant their requests. The town of Sunnyvale did not file a timely comment, so I would deny its request. Similarly, the Cypress Cove Homeowners Association did not file a timely comment, so I would also deny their request. Let me pause there before I turn to the individuals.
I agree.
Looking good? Okay. So we had 63 hearing requests from individuals, if I'm counting correctly. There were a bunch of them. Let's just put it that way. Most of them satisfy the requirements for a referral. So for the purposes of our discussion, I'll just identify by name here the ones who didn't, and then we can read the names of those who did when we present the motion. So I would recommend denying the hearing requests of Andrea Burdick, since she resides far enough from the facility and the discharge route that she's not, will not be affected in a manner different from the general public.
Agreed.
I would also deny Salam Mesfin, since she's raised no personal issues. Lilama Samkudi, since she raised no personal issues in her hearing request. Ninan Samkudi, for the same reason. John Samuel, since he raised concerns about air pollution, which is outside our jurisdiction on this water quality application. Raji Samuel, since he raised no relevant material issues. And Sajin Thomas lives too far from the facility to be affected in a manner different from the general public. And I'll pause.
I agree with you.
All right, we were able to track that.
Yes.
And then we can double check our work when the motion is read by stating affirmatively those hearing requesters whose requests we are granting. Let me turn to the issues. I would refer 8 of them, whether the draft permit complies with nuisance odor requirements, is protective of water quality and the uses of the receiving waters, is protective of the health of the requesters and their families, is protective of groundwater and drinking water in the area, complies with applicable phosphorus standards, is protective of wildlife. I would also refer whether the commission should deny or alter the terms of the draft permit based on need under Water Code Section 26.0282. And finally, whether the applicant has complied with the applicable notice requirements.
I agree on the issues.
We're good on issues? Okay. And I do think that ADR has been suggested and could be productive in this matter, so I would include an ADR referral, and again, the 180 days for the proposal for decision.
Yes.
Okay, and I think that resolves the outstanding issues, and we're ready to hear a motion.
Can I ask Mary one question real quick? Thank you. I'm good.
Great. I will proceed with that motion with apologies before I do. If anyone in the audience feels aggrieved with the way that I pronounce your name, I sincerely apologize. Please correct me afterwards. I would move that we grant the hearing requests filed by Sosama Abraham, Lisa Carlock, Valsin Cherian, Tenetra Clemens, Annie Cullivan, Melvin Day, Bianca Gant, Theo Gant, Aliyama George, Christian George, Gina George, Willie George, Karen Gonzalez, Joe Gonzalez, Larry Hall, Donald Haynes, Sheena John, Beknama Kochakunju, Renji Kochakunju, Ramchand Kumarasan, Emilia Leon, John Masterson, Susan Masterson, Luz Matias Biel, Ali Mir Jahangiri, Elizabeth Mir Jahangiri, Hoa Nguyen, Daniel Palomino, Alice Peter, James Pruitt, Janet Pruitt, Suvik Raha, Blake Rudolph, Kayleen Rudolph, Moni Samuel, James Tyler Schaff, Morgan Schaff, Amy Sherman, Jason Smith, Latoya Smith, Alex Devalasi Vadakathil, Mundakathil Thomas Cootie, James Otis Torrance, Melissa Aline Torrance, Artis Turner, Rahel Valson, George Varghese, Abraham Vargu, Grace Wang, Carla Watts, Veronica Whitehead, Dwayne Williams, Chandranette Starr Williams, Vicky Wolander, Copeland Wright, Wei Zhang, the City of Dallas, and the City of Garland, that we deny all remaining hearing requests and all requests for reconsideration, that we refer the matter to the TCQ's Alternative Dispute Resolution Program for an initial 4 to 6 week ADR referral period prior to the commencement of the SOA preliminary hearing scheduling process, that we refer the application to SOA for a contested case hearing concerning the following issues. A, whether the draft permit complies with applicable requirements to abate and control nuisance odors as set forth in 30 TAC 309.13E. B, whether the draft permit is protective of water quality and the uses of the receiving waters under the applicable Texas surface water quality standards. C, whether the draft permit is protective of the health of the requesters and their families. D, whether the commission should deny or alter the terms and conditions of the draft permit based on the consideration of need under Texas Water Code 26.0282. E, whether the draft permit is protective of groundwater and drinking water in the area. F, whether the draft permit complies with applicable Texas surface water quality standards related to phosphorus. G, whether the applicant has substantially complied with all applicable notice requirements. And H, whether the draft permit is protective of wildlife. And finally, that we set the hearing duration for the proceeding at 180 days from the date of the preliminary hearing to the issuance of the proposal for decision.
Second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries.
Item number 3 is the application by Glado Metals Recycling LLC for renewal of TPDES permit number WQ001861000. The parties have been notified that the commissioners will not hear oral argument but may ask questions. And those who have signed in will be noted for the record.
So colleagues, this is a no increase renewal, which immediately raises the issue of whether there's a right to a contested case hearing. Under the Texas Water Code, there's no right to a hearing if, among other factors, the applicant's compliance history raises no issues regarding the ability to comply with the permit. And there's some disagreement in this case about what constitutes the appropriate look back. The executive director has looked back to 2013, while the Public Interest Council argues that the look back should be to 2011, which contains some more negative information. And there's also a request for reconsideration on this point, arguing that the relevant compliance history period should reach back to 2011. The way I view this is no matter how you choose to look at it, whether or not you look back to 2011, that there are fact issues about the ability to comply. So I would find that the Water Code does not foreclose a hearing and proceed with our analysis based on that finding. But let me pause and gather up your thoughts on that issue.
I would agree. I think there is a right to a hearing that exists. I'll leave it at that for now.
Likewise.
Okay, I do think that in the response to comments on this matter that we should also include a reference to the compliance history report that's in the record that dates from 2011 to 2016. So I'm going to propose that we include that instruction in a motion. And also because that material is part of the record and because it's informed our finding on the right to a hearing this morning, I'm going to propose that we also deny the request for reconsideration. All good? Agreed.
Yes.
Okay. All right, so in looking at the folks who have requested a hearing, I don't see that any of them are affected in a manner different from the general public. They're simply located too far from the facility and its outfalls. The closest is Mr. Kuch's, and he's also the only one who has a riparian interest, and that's his bait business on the Old Brazos River. But it's more than a mile from outfall number 2, which is a stormwater outfall, and it really has no meaningful connection to outfall 1, which is the process water outfall. So in my view, we should deny all of the requests.
I agree.
I think that resolves all the issues that we need to resolve to entertain a motion.
I agree. I would just say one quick comment, I guess. I know there's people that have signed in, and traveled here on this matter, and I do believe that if you were to go back and look at the permit file, the ED did scrutinize the permit application, and they did look at the technicalities behind it, and they gave it a hard look considering the history that this facility has. And so I just want to make that comment, that I am comfortable with the motion, but to kind of reassure is probably not the right word, but to make the point that the ED, in my take, really did scrutinize the permit in light of past events at this site. What's in the new permit? And with that, I can make a motion.
I
Just wanted to
appreciate
make
that comment. Let me just add one additional thought to that. The Office of Compliance and Enforcement is also in the room and
Yes.
heard all three of us, I think, express concern about this entity's ability to comply, and so they will, they should respond accordingly.
Agreed.
I'm in agreement.
With that, I can do motion. I move that we find that a right to a hearing exists on the application, that we deny the request for failure to establish affected person's status, that we deny the request for consideration, that we grant the renewal of TPDS permit number WQ001861000 to Gledo Materials Recycling LLC as recommended by the executive director, and adopt the executive director's response to comments with a modification to response number 3 to include the site information from the initial compliance history report for the period of September 1st, 2011 through August 31st, 2016, prepared by the ED for the initial renewal application.
One quick question. I will just clarify that motion that it was the renewal of the permit for Gledo Metals Recycling.
That is what I intended to say. That's what I would like to say.
I
Thank
second
you.
that clarified motion.
That's what I heard. So with that,
Clarification's always good, so
with that understanding, the motion has been made and seconded. All those in favor say aye.
Aye.
Motion carries.
That takes us to the enforcement docket, old business item 1, and new business items 4 through 38. Items 21 and 22 were remanded at the request of the executive director. I understand that this morning, the executive director also filed a motion for remand of item 24. for further case development, which should also be acted on at the meeting. On items 21 and 31, we have individuals who have signed in and indicated that they don't wish to speak unless the commission has questions, and their presence will be noted for the record. And the executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Brian Sinclair, also of the Enforcement Division, and Charmaine Backens and Janice Hernandez of the Litigation Division, representing the Executive Director. Pending before you are old business item number 1, items 4 through 20, and 23 through 38. The total assessed administrative penalties are $586,574, with $118,346 deferred. $69,982 are applied towards supplemental environmental projects, and $398,246 to the general revenue. The Executive Director requests that item number 24, Bandera Shell LLC, be remanded to the Executive Director for further case development. We also request that item number 35, Heidi Finsterbush and Michael D. Finsterbush, be remanded to the Executive Director. A signed agreed order and penalty payment were received on January 27th, 2020. We respectfully request approval of these items and are available to answer any questions you may have.
I have none. Colleagues, any questions?
No, thank you.
Mr. McWhirter?
OPIC reviewed these items, and we support the Executive Director's recommendation.
I do too. I think it's appropriate to go ahead with approval.
I would make a motion that we remand new business items 24 and 35, and that we adopt old business item 1 and new business items 4 through 20, 23, and 25 through 34, and 36 through 38, as recommended today by the Executive Director.
I second.
Give me just a moment.
Yeah.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you.
Item 39 is the consideration of the monthly enforcement report, and the Executive Director's staff is here to present.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me is Brian Sinclair of the Enforcement Division and Charmaine Backens and Janice Hernandez of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2020 through November. There were 339 effective administrative orders issued, and of those, 41 contained supplemental environmental projects. These orders assess a total of $4,296,265 in penalties, with a payable amount of $2,568,244. $1,130,062 are to be paid towards supplemental environmental projects. 4,093 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 434 enforcement action referrals have been received. There are 1,635 pending administrative orders, with 119 cases that are on the backlog. 198 cases are pending at the Attorney General's office for representation in district court, and 5 judgments have been issued. 1,988 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2018, 19, and 20. We are available to answer any questions you may have.
I do have one. There's a dramatic increase or jump, it looks like, real steep slope on figure 4 in the report, which pertains to assessed penalties. And I'm wondering if you can address what's driving that steep increase, whether it might be a single or handful of larger assessments, or if we're moving more of these matters through, if you know.
I don't really know. I'd have to go back and look specifically at cases. I know that the error penalties so far this year, I think, are over $2 million. Is that right? And so it's being driven by error. But as to what specific case it is, I would have to go back and look and get that information to you.
Yeah, I guess I'd just ask you to follow up with my office, and my colleagues are free to request the same thing if they're interested.
Yes.
Yeah.
But if you look, you can see that the number of orders is basically on track with previous years.
Right.
But this did jump up.
Yeah,
Okay.
appreciate that. I have no other questions, colleagues.
No questions.
I'd love to be counted in that party after the
Yeah,
fact.
make it
if you
3.
Follow with me.
We'll provide it to all 3 offices.
Thank you. Mr. McWhorter,
Yeah, I have no questions, thanks.
thank you for the report.
Item 40 is the consideration for publication of and hearing on amended sections 116.110, 116.116, 116.710, and 116.721, and new section 116.118 of 30 Texas Administrative Code, Chapter 116, control of air pollution by permits for new construction or modification, and corresponding revisions to the state implementation plan. The executive director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Michael Wilhoit with the Air Permits Division. With me is John Minter of the Environmental Law Division. The proposed rulemaking would revise Chapter 116, Control of Air Pollution by Permits for new construction or modification, to make Commission rules relating to permit amendments consistent with statutory changes established by House Bill 2726 of the 86th Texas Legislature. The proposed revisions to Chapter 116 would allow an applicant for a permit amendment to begin construction at their own risk when the draft permit is issued, subject to certain conditions. If adopted, the revisions to Chapter 116 will be submitted to the United States Environmental Protection Agency as a revision to the state implementation plan. A public hearing will be offered on this proposal in Austin on March 12th, 2020. Staff respectfully recommends approval for the publication of and hearing on the proposed revisions to Chapter 116. Staff also respectfully requests permission to make non-substantive revisions if necessary to comply with Texas Register requirements. Thank you. We are available to answer any questions.
I have none. Colleagues, any questions?
No questions.
Mr. McWhorter.
OPIC recommends approval for publication of and hearing on the proposed rulemaking for Chapter 116 to implement House Bill 2726.
I agree. I think this is a pretty straightforward legislative implementation rule package, and
I agree.
think it's ripe for proposal. I'll entertain a motion.
Agree. I move that we approve the publication of and hearing on proposed amended 30 Texas Administrative Code Sections 116.110, 116.116, 116.710, and 116.721, and new 30 Texas Administrative Code Section 116.118 as recommended by the Executive Director.
Second the motion.
Motion has been made and seconded again. All those in favor say aye.
Aye.
The motion carries. Thank you.
Thank you.
I've watched too many hearings or committees over the internet not to try to practice good mic discipline.
You did the right
For
thing
those
to get
viewers
that,
at home.
to get that on the record. Yeah, thank you.
Items 41 through 44 are for closed session, and the commission will not meet in closed session today.
So I'm going to adjourn in just a moment, but first I'd just like to recognize that this is Margie Lagarde's last agenda with us. And Margie, I've appreciated your outstanding legal counsel. You've been a joy to work with. Thank you so much for your service. Colleagues, anything you want to add to that?
I second.
It's always unique how through the course of our meetings, the room gets lonelier and lonelier as matters are dispensed with, and this is a very profoundly lonely note to end the meeting on, but I definitely need to second that as well, Margie. It's been a pleasure getting to work with you in the time that I've been here, and wish you well.
So thank you, Margie. And with that, the time is 10:05 and we are adjourned.